Well, hey, thanks for joining us this morning. This is Anthony Parent of IRSMedic, and joining me is John Richardson and Keith Redmond. We are here today to talk about the name and shame list, the fact that the United States government needs to publish much of your information for the world to see once you expatriate or renounce your U.S. citizenship, something that's a little obnoxious. And really, the point of this is we're trying to show is how these things that the IRS does violates the GDPR of Europe, which has implications because the U.S. wants to tax its citizens worldwide. And now we have sort of a conflict of laws. Those in Europe are protected by the GDPR, or supposedly Americans are punished by its various tax regulations and laws to expose our privacy and rule over our life. Now, one thing that has happened, and I want to go over to Keith for this one. Keith, now there was an appeal filed in the GDPR ruling out of Belgium. Can you explain to us what happened there?
Yeah, well, I think that the Belgian government pushed back on the ruling, stating that they just, and I'm paraphrasing quite a bit, they just don't want to get into bad graces with the United States. So they're going through the motions of appealing this, which is not surprising. That is expected because the objective is, from my understanding, because I'm not directly involved, it's to go to the European Court of Justice. That's the ultimate objective, to have it ruled there, that it violates the GDPR across all member states. And if that does happen, then FATCA would be dead in the water across all member states. Now, that's a big if. We don't know what will happen there.
Yeah.
But that is the ultimate objective, is to get it at that level, on the European Union level.
Got it.
Now, so no surprises that this has been appealed.
Now, question for those, because Jenny Webster has a case going in UK for GDPR. Now, that will not go to the European Union Court of Justice?
No, because as you know now that the UK is no longer part of the EU. But, if the European Court of Justice rules, let's say, that rules that it goes against GDPR, that certainly helps Jenny's case. Not to say that they would rule accordingly, but it certainly bolsters the possibility. But it's two separate things because of Brexit. It's no longer part of the EU.
Right. Now, Keith, could you just refresh us? What in particular about the Foreign Account Tax Compliance Act violated the GDPR?
Could you say that one more time? You were breaking up, Anthony.
What in particular of the Foreign Account Tax Compliance Act violated the GDPR? What exactly?
Well, from my very basic knowledge on that, is any transfer of data outside of any of the EU member states to, let's say, the United States, there's a certain processes have to be in place to ensure that data is secured, number one. But also number two, is that valid to actually do, to send that data without the permission of each individual? That's my understanding.
Oh, right.
The GDPR.
Yeah.
So the GDPR is not just amongst the member states. It affects everyone around the world. So for the U.S. to ask for this information, they have to have a number of processes in place. What those processes are, I don't know, but there's a framework for it. And if they don't adhere to those processes, then it cannot be transferred at all. And certainly the number one process is they have to have permission from the individuals. That's my understanding, for their data to be transferred.
No, Keith, I have a question for you. This is a little bit of hypothetical here. What if the IRS wanted to take all this information from FATCA and just publish it for public dissemination? Would the GDPR be impacted whatsoever?
Yeah, it would. I don't know how,
Yeah,
but it would violate the GDPR. Now, what the repercussions would be, because it's the big old United States, I don't know.
yeah.
Because as the appeal had, the appeal in the Belgian situation, they don't want to get in the bad graces of the United States. So who knows if they'll just turn away. You know what I mean?
That's why that ruling surprised me, that there was a ruling that I was like, wow, that sort of gets in the bad, the initial ruling from Belgium got in the bad graces of the IRS. So I was surprised by that ruling. Now, The reason why I'm asking these questions is to set up what today's topic is about. We're talking about the name and shame list. That if you renounce your U.S. citizenship, that is, you're no longer a U.S. person. And let's just say, in our hypothetical, that you remain. In this case, you are a EU citizen. If you are an EU citizen, give up your U.S. citizenship. The IRS, well, you know what? Why don't I send it over to John Richardson? I'm sure he's been chopping a bit on this. John, good day to you, sir. You have been You've been patiently chomping at the bit. I'm ready to chime in here. So,
oh, wise one.
Start it off, my friend. What's going on? So John, let's talk about this name and shameless. What is this all about?
Well, the bottom line is that under, thank you for putting that up there, Section 6039G of the Internal Revenue Code, the Treasury Department is required within 90 days to publish all the names of people for whom a certificate of loss of nationality was issued on a list, which is published in the Federal Register. And basically, that's what's called the name and shame list. This has its origins, interestingly, in a Clinton era law, 1996, which, by the way, was an incredibly bad year for Americans abroad, okay, for all kinds of reasons. I think there's a sort of added to it. But that's really the bottom line. All of the statutory authorization for all of this reporting, and incidentally, we know that the national anthem of America is report early, report often, report everything, and keep a record of what you report. But, renunciation of citizenship just triggers an unbelievable reporting frenzy where, we can go through the statute. Just so many people and levels of government are implicated by it. It's extraordinary.
So you actually wrote a very nice article. I shared the link for everyone here on tax connections. You wrote a very nice article.
If I may, I just have a quick question because it's been on my mind. With the name and shame list, which I like to call the freedom list, are these individuals who actually have renounced and have also are U.S. tax compliant?
No.
Or are these just individuals who have renounced full stop?
I think, why don't we just go back to the statute and look at the part of the statute, because all these questions about this, of which there are many, I think let me show you the value of actually reading the statute.
Yeah, okay.
Go to the bottom there, Anthony.
Okay.
Yeah. So pausing there, this is the flush language or part of it. So the federal agency primarily responsible for administrating the immigration laws. That talks about permanent residence. Okay.
Yeah.
All right, just go to the flush. Okay, let's go to 2 there. Okay, the Secretary of State shall provide to the Secretary, that means the Secretary of the Treasury, a copy of each certificate as to loss of American nationality under Section 358, which is approved by the Secretary of State. Now, let's be clear on what that means, okay? That's just simply if a certificate of loss of nationality was issued for any reason. Okay, so that could be a renunciation. It could be a certificate issued based on another kind of relinquishing act, becoming a citizen of another country. It could even be, in the case of a naturalized U.S. citizen who was de-citizenshipized, right, for bad behavior or something. So my point is that that's the group, right? Okay, so basically the Secretary of State, once they issue a certificate, has to give this whole list, all right, to the Treasury Secretary. Then we get out of the bottom. And this is, I think, a very, very visually poorly drafted statute.
Yes, yes.
But the flush language, okay, at the bottom, really should just be another section. What it says is,
Right.
notwithstanding any other provision of law, not later than 30 days after the close of each calendar year, the Secretary shall publish in the Federal Register the name of each individual losing United States citizenship. Okay, I think it's confused a little bit within the meaning of 877A and 877A. Now, what that means is that a certificate of loss of nationality was issued. That's the practical impact of what that means.
Okay.
In respect to which the secretary receives the information. Now, Keith, notice that there's no linking of tax compliance whatsoever. So,
Okay.
there are plenty of people who, have renounced, their names have appeared on the list and they've not been tax compliant. There are plenty of people who have been tax compliant. There's no way to know from the list whether they're tax compliant or not. Now, secondly,
Right.
I think this is really, really important because, although this is clear to me, okay, there's sort of a subset of people out there who think that the people who are on the list are definitely covered expatriates. And I want to show you where the confusion comes from. Anthony, could you please go right back to the top of the statute? Just go right back to the top. When you get to the top, let me explain where the confusion comes from. Yeah. Okay. So I'll move down a little bit in general. Okay. Now notice, okay, this is paragraph A. In general, notwithstanding any other provision of law, any individual to whom 877B or 877 applies. Okay. Now that is simply the part of the statute that puts a reporting obligation on the individual, okay? And that is basically the 8854, right? If you're a covered expatriate, then you have to report all your assets. But I think that what happens is, Anthony, if you go back down to the bottom. So if you look at the bottom, that flush language, this is such a visually poorly drafted statute, all right, that I think it's easy to somehow incorporate that into applying only to the first group, right? Or rather, applying to the first group, in paragraph A. In other words, linking it somehow to, people who are covered expatriates, sort of thing. And that's completely incorrect. Does that make sense?
Okay.
To everybody?
Yeah, I see what's going on, because that flush language should really be number 4.
It really, well, not even that. I don't even think that.
Or actually should be up a level, I think. It should be
Anthony,
moved up.
Move up. Sorry, could you move it up a little bit?
Yeah, I think it should be. I mean, it seems like.
Go, keep going. Keep going. Keep going. I'll tell you when to stop. Keep going. All right, pause there. It should be a new paragraph E.
Yes.
Okay.
Yes.
That's how it needs to be read.
Yeah.
And this is the source of absolute unbelievable confusion. Okay. But that's the reason. Now let me add something else, because as we know that this podcast today was to some extent motivated by a Twitter discussion last week. Then the question becomes, well, how, why are the green card holders on the list? Okay. And the answer to that, and this goes back to 1996 as well, if you could open up a tab, Internal Revenue Code 877, subparagraph E, you can open that up.
IRC, okay, you got it, bud.
877E, yeah. Okay, so. Okay, so if you could expand it a bit, thanks, and move down to E, if you would, please.
Alrighty.
Keep going.
Oh, not that E, not that E. Here we go.
There you go. This one, yeah. All right. I mean, the legislative drafting, this is just unbelievable. Okay, it's so it's so hard. You have to go here, there, everywhere. But this is a provision again from the same 1996 law that created the name and shame list, which also added 877E here. And the heading is comparable treatment of lawful permanent residents who cease to be taxed as residents. Okay. Now, let's take a look at paragraph 1. In general, any long-term resident. Okay, now that's somebody who's had the green card long enough, 8 of the previous 15 years. Okay, who ceases to be a lawful permanent resident within the meaning of 7701B6. Okay, we won't go there, but that means abandons the green card effectively. Now it says shall be treated for purpose of this section and Notice it says 6039G. In the same manner as if such resident were a citizen of the United States who lost United States citizenship. Okay. So what that does, I think, treat it in the same manner. I think that what that does is it allows them, and I think the better interpretation of it is that because we're talking 6039G, that would include all the provisions of section 6039G, which would include the name and shame list. Okay. Now, notice that applies only to long-term, right? 8 of the last 15 years. So that's what I think is going on here, or at least, that's the clear statutory route, if you will. If we go back to 6039G, if you want to go back there for a minute, go back to the bottom again. Yeah, okay, I just up a little bit. Okay, you'll notice 3 says the federal agency, just stop there, primarily responsible for administrating the immigration, shall provide the name of each lawful permanent resident within the meaning of 7701B6 whose status has been revoked or administratively, judicially, So there you go. That's imposing a reporting obligation really on the immigration people to send the same information to the IRS or Treasury Secretary. And then 877E seems to inject itself into the flush language at the bottom, because although the flush language says, well, we're talking about people losing United States citizenship, we go back to 877E1, okay, that mandates comparable treatment under 6039G for green card holders, long-term green card holders who lose the green card. If all that makes any sense to you.
So it's poorly written.
Oh my God!
And I highlighted this while you're talking. This just cracks me up. Like they can't even they don't even have the energy to go through to say, well, who is the federal agency primarily responsible, or nor do they want to have that specificity. Like, well, we want to keep it vague, so just finance.
Well, they're doing it.
Responsible for administration and immigration laws. Well, okay, well, who is that?
What they're doing, Anthony, as they often do, is they're writing it in general, and they'll put specifics and regulations and things like that.
Yeah.
But I think what we might
they're not even defining the federal agency. There's
but they might do it by regulation. But remember, they're also allowing, they're trying to write presumably they're trying to write a statute that would allow for, this type of administrative stuff, to go from agency to agency. But, Anthony, I think, let me just pause there for a minute, because I don't know how clear I was in that. Does that make sense to you so far? The bottom line is, that there's no doubt that the name and shame list is required to include every U.S. citizen for whom a certificate of loss of nationality has been issued.
But it doesn't. But it doesn't. There's so many people whose names have never been on that list.
That's exactly right. That's exactly right. It does not. But it's kind of irrelevant to the requirement. But you're absolutely right. Okay, and not only have many people been omitted. I know personally, not off the top of my head, but I've been aware over the years, right, of people whose names have been omitted on that and never appeared.
I know quite a few.
Who the editor of American Expat Financial News Journal, took a real interest in this. And if you go there, you'll find, she effectively has been reporting on the name and shame list for years. And in a recent series of posts, she even pointed out that people were named twice. So, there's a huge a lack of consistency between what the law requires and what actually happens.
Hey, John, just a quick aside. So you probably know, do you know why I'm highlighting this?
Yeah.
So the US government knows how to write a law to mandate an obligation on an individual. Look at that. They do. And the reason why we're bringing it up is it's one of John's arguments on the FBAR. And his argument is that it actually only puts an obligation on the US Treasury or Secretary to create a report. That's actually what you do. And if you actually read it carefully, that's actually what it says. And here, I think, is a great example of the difference in language. So that it is true. They know how to write a statute. Let me just pull it up so people can compare for themselves very quickly, because it is so related. what is it? 5113. Why can't I remember my 50?
5314.
Thank you. That's what it is. Thank you. And so here it is. So this is the FBAR authorizing statute. Okay, it's 31 USC 5314, not Title 26, because they're from the Bank Secrecy Act. So here it is. Here's how they did. The Treasury of Secretary shall require a resident or citizen of the United States person to keep records in here. And so this is the obligation on the Secretary of Treasury, and this is an obligation on an individual. And that's really, I think we have. Oh, let me go back over here. And that's what we have here. And that's really, so supporting John's argument is like, yeah, the FBAR is not the authorizing statute for.
Yeah. So your point, Anthony. Sorry, I now see where you're going with that. I didn't quite understand initially, but I think you make a very, very good point. Is that when Congress wants to impose a reporting obligation on an individual, they know exactly how to do it, and that's done in 6039G, but it's not in the 5314.
Right.
I agree with you completely. I agree with you completely on that. I mean, I'm amazed that this was not even raised in the Bittner FBAR case, because I am convinced. I mean, there's no possible way that 315314, which is the FBAR law, there's no possible way that imposes any obligation on an individual.
Right, and then my argument and that John's argument is it's not an obligation on the individual, and my argument is like that's also true, and there's also no obligation to report a foreign bank account. There's none. This is all about totally. I know we've probably beaten this to death, but I don't think so, because FBAR still exists. So when FBAR is gone, then maybe I'll stop beating this to death. But it actually requires you to it's actually a report of your foreign financial a person with a foreign financial agency. And for the rest of the statute, clearly defines a foreign financial agency as something totally different than a bank. Totally different. That's just sort of, again, they do know how to do it. So I guess in this case, though, at least there's some law behind this name and shame list. It's not just regulations, so we should count ourselves lucky, because they can simply just do it with invented regulations, right?
There's good news. The good news is that there's a relatively clear law, and the bad news is there's a relatively clear law.
Yeah.
If we look at it that way, I guess one point on the FBAR before we end that discussion is that I think that the 5314 is an example of extreme tyranny. Okay, because what you've got is a law that's completely incomprehensible. I swear to God, there is no normal person who would go to 5314 and say, "Oh yeah, that's obviously a foreign bank account reporting law." Nobody would do that.
No one.
I mean, it's a pure delegation to the Treasury to make up any rules it wants. I find it hard. I mean, I'm being honest here. I find it hard to find this stuff. Okay. I mean, it's not like, you look it up really, 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 really easily. Okay. I mean, you have to kind of dig, and I don't understand. I mean, I'm not, necessarily the sharpest knife in the drawer, as they say, but I'm not the stupidest either. And I've written about this stuff, and if I find this difficult, I mean, can you imagine, how the average person would relate to this, if at all?
Yeah, well, and I would say, everybody has reasonable cause for the reasonable cause defense for not filing an FBAR. What's that? Oh, I read the law.
Well,
There's nothing about it, nor could it. And and my other problem with this is like, well, where is this foreign financial agent report? Where is it? The fact is, Secretary of Treasury never created it. Didn't create the report that 5314 calls for. Created something totally different. But where's the report for reporting foreign financial agents? People like Joe Biden could have a bunch of foreign financial agents, but we don't want to know that. But we want to know the bank account information of someone who's, we want to know the bank account information of some nomad capitalist in
yeah, well, it's applied, of course, individually, selectively, and I think it's the sort of thing that probably has been weaponized, and I think certainly will be weaponized.
Yeah.
I mean, it's weaponized even indirectly. We talked about this last week. I think it's weaponized through inflation, right? Because by inflation, more and more people acquire the reporting obligation every year, and then Congress in its wisdom realizes that, well, shouldn't we be indexing the penalties to inflation? So they index the penalties to inflation.
But not the
I mean, I think that the FBAR law, the way it's written anyway, is probably a symbol of United States tyranny, actually. But let's go back to the other one.
Yeah, let's go back. So
take that apart a little bit and show you how that imposes different obligations on different people.
Okay.
So actually, on the Tax Connections article, yesterday, in anticipation of this, I did a quick web search on this stuff, and that article showed up. And I'm going to tell you, I don't remember having written it, which makes me wonder if it's something that is something older that I wrote, because I noticed it's a 2023. But anyway, but I did think it was a pretty good article. It was exactly like the type of thing I might have written. So
yes.
I thought, well, sure, we can use that.
It looks like something I would have written, so I probably did.
But I think that the main point here is that to go through it and show you how it really is a reporting frenzy and how it puts different obligations on almost everybody, okay? And
this is just because you no longer want to be a U.S. citizen.
Well, no, we can get out. Let's go through it slowly.
Okay.
Actually,
the statutes.
Go back. Okay, well, here's who. Okay, here are the people, right? So individuals. Okay, pause there. Well, individuals. This is the statutory obligation for file the form 8854. Now, in other words, what it says is the people who are covered expatriates have to file the 8854. Now, some people might wonder, well, hey, I wasn't a covered expatriate and I renounced, but I seem to have to have filed an 8854 too. Here's how they got around that. This is sort of a form of evil, I think. So to avoid covered expatriate status, you have to certify tax compliance for the 5 years prior to the year of renunciation. And what they've done is they have put the certification of compliance on the 8854. So although you might be below the 2 million net worth, the 8854, if you look at their description of this, is where you certify the 5 years of compliance. So that's what they've done, is created a backdoor way to get people's financial information when the statute itself doesn't require it. Okay. So this is really, really interesting. And if there are any lawyers or accountants listening to this today, one of the questions that I've always had in my mind is, what if somebody just sent a letter to Treasury saying, or an affidavit saying, I certify I've been in compliance with my tax obligations and not filed the 8854 because they were below the 2 million? I wonder what the response to that might be. I mean, I think you've satisfied the legal requirement.
Yes.
But we'll leave that to those who want to get into a discussion with the Treasury Department, which I don't think people should bother. But it is interesting, all right, that the 6039G requires reporting if you're covered, if you're a covered expatriate, okay? It doesn't require reporting if you're not a covered expatriate. but the way you certify one of the requirements to avoid covered expatriate status is on the 8854. So that's kind of it.
I think, also filling in the blanks with, not applicable, and then just certifying, that might be another way to try it.
Well, I mean, I think it's interesting, right?
Yeah.
Dear Miss Yellen,
Yeah.
Section 78778 requires me to certify or to confirm that I am not a covered expatriate, that I have met my tax obligations for the last 3 years. And here's under oath, here's my affidavit that I have met those requirements. I trust this meets the requirements of the law. Sincerely yours.
So, one of this just sort of reminds me of kind of the common overall theme that people have. They're like, the way that most people will approach the IRS, like, oh man, they're really the authority. Do you understand how much the IRS lies? I mean, this is a form that is completely misleading. And the IRS is proven wrong in court all the time. The IRS is not this authority that it wants to be. It needs to be challenged again and again and again. It's when people don't challenge it, then they become the authority. And that's really it. Here they are clearly trying to mislead and get information that they're not entitled to. And they're doing it, by lying. I mean, having a form that makes it look like it's supported by the law, that's kind of lying. That
I don't know. I mean, I guess that, you wonder, well, to what extent do they read these? I don't know. But the real problem in this, Anthony, is not the IRS. The real problem is the tax compliance community, because once a critical mass of the tax compliance community interprets a law in a certain way,
right? Yeah.
Then that's it. Okay, they've effectively, I think, changed the law. And this is, I mean, so you get, all these people who, take a defensive posture. Well, we might as well file a 3520 or something. I mean, my God, that's the worst thing you can do. But they'll do it. And then, that sort of morphs into, well, this is standard practice in the industry, et cetera. But anyway, so the 8854 is the reporting requirement on individuals. Okay, so let's move on down here a little more.
Yeah.
So the next reporting requirement, keep going, would be the State Department, right? Yeah, here we go. Government agencies. Here's the next group who have to report, right?
Okay. So and again, so you have an 8854 that there may be a statutory basis for the information, or there may not be, depending on what.
Well, there is a statutory basis
if you're not if you're a covered expat.
The net worth is high. If you are a covered expatriate,
there is, but you're not.
Not if they aren't, right?
Yeah. Yep.
Now here we go, government agencies who are part of the reporting frenzy. So my theme is that there is nothing that generates more reporting than renouncing citizenship. Nothing. It's a reporting frenzy. Like, once a certificate of nationalism is issued, everybody in the world steps up to report. Okay, so here we go. Now we look at the government agencies. Okay, well, we have the State Department. We've already talked about this. Anybody for whom a CLN has been issued. Okay, and that's not just people who renounce, it's any reason at all. And then we have all individual green card holders who file an I-407 to abandon green cards, right? I mean, this is interesting because this is clearly not something where there's any consciousness at all, I think. But, that's what the law clearly says, right? So the government so the individuals must report if they're covered expatriates. The government agencies, who are the gatekeepers, if you will, whenever an I-407 is issued or a CLN is issued, must report that to the secretary. Okay, and let's keep moving down. Yeah, no, I want to make the point again that the reporting to the reporting by the government agencies, it doesn't matter if they're a covered expatriate or not. Okay, and then we go to this flush language at the end, which this has been interesting discussions, Anthony, because I realize that really needs to be redesignated as E so people can read it.
Yeah.
properly and contextually, because this is a very separate reporting obligation. And this one is on the Treasury Secretary, right? Specifically on the Treasury Secretary. And this reporting obligation is the name and shame list, okay? And so we look at it as per citizens, well, notwithstanding, reporting of each individual losing United States citizenship. There you go. I think, the confusion may be within the meaning of 877A, but I mean, that's just the notice requirement. That's all that reinforces. Then there's no reference to green card holders here, but there is, if we go back to 877E, that sort of provision that appears to bootstrap it in, right? So there you have it. I mean, tell me, Anthony, can you think of anything else in the world that generates such a reporting frenzy?
Yeah, entering the U.S. tax system.
Sorry?
Yeah, entering the U.S. tax system creates it, and then
not
leaving
to this
it.
extent. Not to this extent.
Yeah. And this is.
I mean, it goes
well,
after.
right, and the cross agency reporting is well, we're not even going to define the agencies. We're just saying, hey, who's ever responsible of this? You're who's ever responsible of this, let's get this all out there.
Then you ask yourself, about, I mean, Americans are so numbed by, what I would call the tyrannical overreach of all this, that, very few of them even consider, like, what is going on here? I mean, at its core, what's going on is the Treasury Secretary is reporting private information about people in a public way. I mean, what's to stop them from, putting together a registry of, people who, I don't know, bought a foreign car, for example. Look, here's a group of people who didn't buy an American car. Let's publish their names.
Yeah,
it really is insane, and it shows the vindictiveness and the irrationality of this. And going back to Jenny's lawsuit, for example, I mean, I think that her lawyer, Mr. Nacedo, if I'm pronouncing his name properly, has made the point that this really is an example of a data breach, right? It's exactly
right. It's a
PR should be protecting. I mean, maybe
it's a mandated data breach. That's what it is. It's a mandated. The law is going to force you to give up your privacy, or else.
Well, I mean, this is extraordinary stuff. It is. Why is it the business of the general public? I mean, maybe you can help me with this. I can't understand it. Why is it the business of the general public? So anybody in the world can look this up. Or even they're just automatically exposed to it. Why is it the business of the general public if somebody abandons a green card or relinquishes United States citizenship? Can you help me with that?
It seems like if there was a needed list for that, there'd also be a needed list for every U.S. American person. Seems like we should have that. It's like, well, okay, why don't we get an audit of all the people that you claim are your congressional district? Why don't we get an audit of everyone who's a voter? Why don't we see the names of everybody then? Because if that's what you're saying, like, well, it's really critical that we know all these people and it be public. I mean, the government knows who it is, right? They know full well. They don't need to report it to know.
They update their immigration data, but their database, et cetera. I mean, they do that. I mean, it really, really is hard to see this as anything but, extreme vindictiveness. They wrongly think that, that this names and shame people. It does not. I mean,
no, it just proves what you are, right? It just proves what the American. It's like, all right, you're vindicating everybody who said you guys are total monsters.
Well, I mean, what you're doing is you're creating a public list of people who've opted for freedom over tyranny. I mean, do you suppose
you're so upset, right? You're so upset that you cannot, right? I mean, it's so.
And it's not even a complete list. It's not even a complete list.
Well, I mean, that's a separate issue. They don't do what they're required to do. Okay, they don't do it properly.
Yeah.
So I want to.
Right.
So, Keith, now that you've been listening, and I think there was a tweet going on, and I can't remember what it was, but I think there was a tweet where someone says, "Oh yeah, here is the name and shame list has created problems for me for if you're identity theft. Keith, what would you say now that we've gone more into this? Now, what your perspective? What would you say about this now?
What about as far as identity?
Yeah,
theft?
I mean, this is the thing. It's like, well, why are we concerned about this name and shame list? What's the real world problem with publicizing people's personal information on a list?
Well, it's for public consumption, so who knows how it can be used.
Well, I would say identity theft
I don't
is one of them.
I beg your pardon?
Identity theft is one of them, and then the other problem, and this the biggest problem I have, is that you have a lot of people, a lot of governments around the world who want to get to a lot of people who might be dissidents in their country. And they're looking for these people because, hey, they want to spend a visit. They want to visit them and just sort of, hey, we want to have a little talk to you about your situation. Well, now, thanks goodness to the U.S. Treasury, we now know where to find those people. We now know where to send our agents to make sure that we can punish these people for running afoul of them, because now we have information that we wouldn't have been able to get any other way. And now we can have everybody in the world harass them because, hey, look, it's public information, and they could have found them anyway.
It's fascinating. It's fascinating that all this discussion over the years of these American expat groups and everybody says, well, there's the name and shame list. I don't think I've ever seen anybody say what is going on here. I mean, just the very existence of this is so offensive. On the other hand, I just had a thought. You know how there's a lot of people in the world who are just waiting, to have their name published in the paper, or they want to be recognized in some way. This is your opportunity to be recognized. If you renounce,
get your name in the paper.
Get your name in the paper. My name in the paper. If they make a mistake and don't report you, sue them. And get some more publicity out of it. But
I like my name in print so much. I worked at the newspaper. I mean, that was a good thing. So here it is. Here's your opportunity. Anyway, I got some comments here. Here's a commenter. Amre Yadin commented, people should file the AD 54 and fill in the only 5-year certification, as we've been talking about. This is what I would say too, is I would, if I was going to do that, I would address a cover letter. Dear Secretary, attaches Form 88558. As you see, we certify the 5 years of compliance. However, due to the law, we don't see that this applies. Therefore, we left it NA. Please let me know if this is acceptable. Here's my contact information. That's
this is interesting. I've had this, obviously, not the first time I thought about this. I've had this question from a number of people. My advice is to fill the thing in and be done with this problem forever. All right. And not, I agree it's completely idiotic, and I don't think there's a statutory basis for it. But, if people are going to go to the trouble and renounce, they want to put this behind them.
Because it doesn't get you out of the name and shame list. Yeah. So it doesn't, not do it.
Well, no, it doesn't get you out of the name. Right. It's nothing to do with it. I mean, they just want to put this behind them. I think, so Mr. Yadin, I think you're probably right in the sense that I think that probably is, within the confines of the law, a reasonable legal response to this. I'm not a covered expatriate. Here's my certification. That's it. Of course, given that it goes to two places, as you know, the 8854 has to go separately to Treasury and as part of the final filing. I think it's better than an even chance. It's going to start a discussion. If you want to do that, fine. If not, I would just move on.
We got another comment. Suzanne left a comment for us, and I would say she's right about this. The U.S. already views immigrants with suspicions of crime. So this is just adding to the narrative that those who expatriates should be named and shamed and punished. Yeah, thank you. That's a brilliant point, Suzanne. You're right. It's
right, because they are bad people. They are very bad people.
And that's why Senator Ron Wyden can get out there and say, oh my God, all these people overseas that's where the real money is, guys. Right. You're creating an implicit argument that there is a reason why they're doing this, right? And Suzanne's got she wants to share her status. Her Her eldest is on the list all after 2 years of renunciation, and she's never been on it.
Can I
Yeah.
ask a question of Suzanne? Sir, thanks, Suzanne, especially for your regular comments on this. But do you feel left out? Are you upset that you've never been on the list? I'd just like to know. How do you feel about that? Do you feel that makes you even more worthless than
they don't even, it's just, wow. They're
They
really,
couldn't even take the time to shame you.
right, that they didn't care enough
I mean,
about
like
you
you were
to vote
so
you.
irrelevant
Yeah.
and worthless that you weren't even worth publicly shaming. I mean, how do you feel about that?
And I gotta say, guys, and I think this. I want to wrap up here, but I'm having a hard time not thinking of my other project that I want to work on that I have no time for. And that project that I want to work on is something called the Lincoln Files. And so if people are interested in this, just leave in the comments if this is something you'd be interested in. I have another channel that I want to start called the Lincoln Files, because one of the biggest problems that we have in this country is that people look at Abraham Lincoln as a force of good. And they look at the Civil War as something that was necessary to bring this country back together. But the foundations of the Civil War are really this. This is what it comes down to. In 1861, the Morrill tariffs were passed. Those tariffs put up to 50% tariff on imported goods, including farm implements. Now, the South had no manufacturing, really much to speak of. So these tariffs were specifically designed by Republicans, Abraham Lincoln, his predecessor being one of them, to punish the South. Okay, to punish the South. Now, they all knew, and this is the thing, they all knew what was going to happen, because in 1825, the tariff of abominations were passed, or 1823, with a 25% tariff, half of what the 1861 tariffs, and it nearly led to a secession of South Carolina. Jackson stepped in, said, okay, let's get a reasonable rate. So this is what we need to understand. This is exactly, so the parallel between the South objecting to this insane tax rate, and then, well, what happens when you upset the Union and don't give them what they do? Oh, they'll start a war against you. They will start a war against you because you don't want to pay what you don't think you should. And now they're going to change the argument and say, well, you can even leave the Union, which is not what anyone believed at any time. Lincoln invented that. Everyone agreed there was a right to secede. New England threatened to secede from the Union for years because they didn't like how things were going. Everybody agreed to it. And so that's what we have here. This is just sort of an extension of that federal government, like, you're not leaving us. We'll kill everybody in the world if you try to do that. This anger that we have. And so I kind of am curious if people would have any interest. It'd be a separate channel. I need to find the time to do it, but go piece by piece and explain, here is the foundation of where we are right now. And it actually comes from the Civil War. That's where we get our first income tax, Revenue Act of 1862. That's where it is. And so in order to enforce this tariff, Lincoln creates a new income tax on every American everywhere to pay for his war of choice. And that's actually the narrative that people need to understand, because we go around thinking, well, this was a good thing. This was a good thing. Like, no. It destroyed it. It was an awful thing. Suzanne responded here. So if anyone has any comments on that, please leave them in the comments.
I hug my CLN and protect it with my life. Well, actually, you're probably 3/4 serious, but one of the things that I suggest to people when they get the CLN is that they make a number of copies and put the original in safe deposit box, because
Good idea.
the CLN is probably the most important document you have in your life. In fact, Anthony, you're as a lawyer, do you remember a movie? Well, do you know of a movie from the 70s? I know you don't remember it, called The Paper Chase.
I know I meant to watch it because it was about
okay, you got to watch it. What it's about is a first year Harvard Law School. Actually, it's a great, anybody who wants to go to law school should watch this movie, because they use actual cases and stuff. But anyway, the idea is that Harvard law degree is one more piece of paper and these people trying to get it. What about a remake of The Paper Chase with the CLN being the most important document that they're trying to get?
Somebody's trying
to Netflix or something. 10 people desperately trying to renounce U.S. citizenship.
And here's your all right. Here's a follow-up. What concerned me, Suzanne says, is when the State Department questioned the right to expatriate, then said it was done as a favor. They also said the fee was going back down 7 months ago.
Well, where are you getting that? What's the right to expatriate that's done as a favor? Are you talking about the lawsuit, Suzanne? Is that what you're talking about? I will say this, okay, if that's what you're talking about, that lawsuit, which I thought was very well argued, great. The lawyers, Mark Zellen, Noam, did great work on that. But I will say this, that the government's response was there was no constitutional right to expatriate. Yeah. Oh, yeah.
Oh, okay. Okay. So, yep, she said, yep.
Absolutely. Maybe that's what she's, okay. So that's what she's talking about. Yeah.
And well, again,
that's extraordinary stuff, isn't it?
Yeah, Lincoln said there was no constitutional right to secede, and everybody in the world disagreed with that. But then, hey, well, guess what? I got the guns, and that's what it came down to, because there was a right to secede. Everybody recognized that. Even Lincoln recognized that. He did. He changed his mind on that.
What's fascinating, Anthony, is that, if we go back to the old 1868 Expatriation Act, which is still on the books, which basically says, expatriation is a natural right and everybody has the right to expatriate. Basically, the position of the United States apparently is that everybody who's not an American citizen has the right to expatriate. Okay, and this is, this is really, really concerning. Now, Lucy Saylor, who's a history professor, I think in New Hampshire or something, wrote a fascinating book about the history of expatriation. I can't remember the title, but you can find it. Incredibly good book. And at the end of one of the chapters, she openly ends the chapter with, well, does the Expatriation Act apply to everybody who has or does it exclude Americans? And I think that, that was a very astute comment. And I think it is very clear that at least the litigation position of the U.S. government is that there is no constitutional right to expatriate. Now, let me tell you, though, why I think this comes up is that, so, you want to bring a claim against the U.S. government on the expatriation issue, you have to demonstrate that expatriation is sort of a fundamental right, to get over the procedural hurdles of who has to prove what, right? Because normally the rule is government can do anything it wants unless you're in an area of fundamental rights and stuff like that. So the very existence of the lawsuit seemed to me incentivize the government to respond reflexively with, well, there's no constitutional right to expatriate, because in terms of the machinery of the lawsuit, what that did is it pushed the burden back over to the applicants, the plaintiffs, to demonstrate that expatriation was or is a fundamental right. But the bottom line is that's chilling language. And I would expect, well, I don't know where this is going to go, but it would not surprise me, let me put it this way, if they dramatically increase the fee to renounce U.S. citizenship to try to dissuade people from doing this. I mean, clearly and objectively, and I don't say this in an intent to be at all humorous, but clearly at $2,350, the CLN is very, very undervalued, okay? Because, the truth of the matter is, for people who don't live in the United States, that there really is, you could not invest $2,350 in a way that would give you a better return on your money. I mean, it's the only investment I know that guarantees a return
year after year,
24/7. And I think it could go way higher and people would still do it.
Still be worth it. Yeah. Well, I want to finish here with one more comment from Omri, because this is a helpful reminder for people. I was lucky enough to avoid the whole issue by leaving the U.S. and returning my green card before staying in the U.S. long enough to.
So he means he was not a long-term resident.
Yeah. So
15.
Yeah, so that there you go. So if
Well,
you're getting close to that time,
I mean, was it luck
Yeah.
or was it planning? I mean, one of the things that that I see. I mean, this is as you know, this is sort of what I do is help people with these problems. Is that there's a very much a heightened awareness of this 8-year trigger,
yeah,
and some people leave, some people don't. Some people might become citizens even to toll the problem and then figure they'll renounce later if they want. I don't know, but people are aware of it. There's no question about it. And let me ask you this question: in I guess it was 61. President Kennedy made what I thought was really an incredible speech at the Berlin Wall, and everybody should go and watch that speech. The highlight I think is something to the effect of, freedom is difficult, freedom is difficult, democracy has many difficulties. But then here's his line: but we've never had to put up a wall to keep our people in. Right, this is what he says. But we've never had a wall to keep our people in.
Oh, yeah.
Well,
What do you need a wall for, right? Walls are for when walls are a last resort. They don't need a wall. No.
well, and interesting. Then you go forward to 2012 in the Republican nomination process, and it was Mr. Paul. I can't remember his first name. Rand Paul's father.
Ron.
Ron Paul. I'm sorry. They started talking about. I think it was Trump's saying, "Well, we want to build a wall, to keep people out." And Ron Paul, I think, very astutely said, "I guarantee you that wall is going to be used to keep people in." And it was fascinating that in 2012 people laughed at him. Question:
Yeah.
we have 2024. We're going to have a repeat of all this stuff. I wonder if the same issue were raised in 2024, if people would laugh if somebody said that. I'm not so sure.
There would be there. I think we still would have most people laughing because most people don't understand. And that's what we're trying to do. And by the way, that's what we're trying to do on this entire podcast. We're trying to raise the awareness. The problem that we have is that when you're affected by this, not enough people are affected by it to have the political clout to do too much about it. We need to educate the entire public, say, look, everything that they're doing internationally is just a trial balloon for what they're bringing to you. So if you want to defend yourself, the best defense is actually maybe standing up for somebody else. Could very well be that could be your best protection. Protecting their rights is the best way to protect theirs. If you are indifferent about their rights, well, you know what? It goes the other way too. And that's the thing. When we get split up, that's how they're able to get. That's how this entire nonsense is able to happen. We're all split up every week.
Well, Anthony, you look at the Biden Green Book the last couple of years, and so many of these legislative proposals, which are largely based on what some people characterize as taxing unrealized income, among other things. Which is what
which is otherwise known as not income.
Yeah. But these are things that have been applied to Americans abroad for many years. Okay, which is kind of interesting. So we live in very, very interesting times. That's for sure. I mean, these issues are interesting. No question about it. I will say this: I'm glad I'm not 20 years old, starting out in life. I would not want to deal with this for the next 50, 60, whatever years. Because I think that, precisely because of the lack of awareness, I think things are going to get an awful lot worse before they get better. If nothing else, our discussion trying to parse the language of these statutes shows you, and I think this is an incredibly important point, that there is no better place to mask pure evil than in a tax code. None.
There is the quote. All right, we're going to end there. That is absolutely true. I want to thank you so much, John. Keith had to step off. Thank you so much, John. What a great episode today. I just want to tell people, make sure if you subscribe, turn on that notification so when we go live, you'll be there. Then you can comment. We really enjoy the comments. Want to take Suzanne and Anamri today for their great comments today. We really, really appreciate it. We're going to be monitoring the situation. I imagine our next podcast is going to be on a related topic. I am going to take a look at Kennedy's speech here because that definitely seems like something.
I think, frankly, we ought to do a podcast on that. Of course, it wasn't Kennedy; it was Sorensen who was a speechwriter. Okay, but in any case, brilliant speechwriter. But it really is an extraordinary speech. If you look at it, I mean, it was an extraordinary speech at the time, but I think that it is an incredibly interesting speech if we compare where we are in 2023 to, the ideals of 1961 or whatever was going on there.
Then Kennedy passes subpart F, so.
That is correct. That is correct. So what was happening was, I mean, we'll leave this for the next.
Yeah, we'll leave that for we'll.
But yeah, no question about
it.
I
think that's what we'll do for next time. Is just sort of like, look, you said this, but let's take a look at what you're doing, and I think that will be our next one because I think it's a wonderful, like that American blindness to our own tyranny, and that's where we can come up with this flowerful language and totally.
Anthony, as I've said previously, right? I mean, the purpose of FATCA, in part, was to prevent American citizens from being able somehow to get additional rights if they were to leave the United States, right? I mean, that's in part. I mean, the United States actively exports human rights violations.
Top exporter.
It's incredible.
It's amazing. Yeah, right. They are right. That's what they traffic in.
But I don't think people were talking about that on the 4th of July celebrations. Let's celebrate.
Yeah, right now they missed that. All right. Well, indeed. All right, fellow Americans, we're going to continue on our struggle, and we're going to find that freedom that we've been promised someday. We're going to find it. This is Anthony Parent for John Richardson and Keith Redmond. Thank you so much for joining us today.